This short presentation will provide an overview of the mediation process. I am John Hertz, and I want to help you feel more at ease about your upcoming mediation. We all find unfamiliar situations to be stressful. By making the mediation process more familiar for you, I hope to reduce your anxiety about the process. In a typical mediation, you will be in a conference room with your attorney. The opposing parties will be in separate conference rooms. If your case is a personal injury case or an insurance matter, the attorney for the insurance company will be in a separate room with a claims representative from the insurance company. The claims representative may be there in person, or sometimes the claims representative attends the mediation by phone. In any case, I expect the parties to attend the mediation with full authority to settle the matter. Before the mediation, I review confidential mediation submissions that are provided to me by your attorney and the opposing attorney. The submissions include the parties' position statements, a summary of the case, and supporting evidence. The supporting evidence might be in the form of an accident report, a summary of a deposition, a summary of medical records, or a report from a doctor or another expert. By studying those mediation submissions, I know a lot about you, your case, and the positions of the parties before we begin the mediation. Mediation is not a trial, and I do not act as a judge or jury. My role as a mediator requires that I be neutral and impartial. I work with all sides to see if a settlement can be reached that the parties and their attorneys can agree to. We will only reach a settlement if you and your attorney agree to it, and the opposing party and attorney also agree to it. If we do reach a settlement, it is customary that I reduce the agreement to writing and have it signed by the parties and the attorneys. As your mediator, I will talk with you and your attorney about the strengths and challenges in your case. I will also talk separately with the opposing parties and their attorneys about the strengths and challenges from their side of the case. I will quickly determine what the parties can agree on and define the areas of disagreement. The mediation process is intended to be informal. You will not be questioned like you would in a deposition. You will not be put on the spot, so to speak. However, with permission from your attorney, I will want to chat with you informally to learn a little bit more about you and your case. This will be done with your attorney present, and you should understand that your attorney is in charge in your room. During the mediation, settlement offers and settlement demands will likely be exchanged. When I bring a settlement offer to you and your attorney, you will have an opportunity to talk privately about the offer of settlement. There may be additional times during the mediation that you or your attorney want to excuse me from the room and talk privately. That is perfectly fine. There may be other times that I will ask your attorney to step out and talk with me privately. Sometimes those kind of discussions facilitate settlement. During a mediation, there are often a number of rounds of negotiations. One important thing to remember about mediation is that I will be talking with you and your attorney in confidence. I will only share what you and your attorney tell me with the opposing party if I have your permission to do so. This ability for me to talk with the parties and the attorneys in confidence often allows me to learn something important about the case or about the parties' positions that will help me facilitate a settlement. During the mediation, we may discuss the advantages and disadvantages of a particular settlement offer as compared with taking your case to trial. At the mediation, you may learn about advantages of a particular settlement option that you had not thought of before. Now I'd like to give you a few helpful tips that will help the mediation process go as smooth as possible. Be well rested on the day of your mediation. Clear sufficient time off your schedule for the mediation as directed by your attorney. Plan ahead for the mediation so that you can focus solely on your case. If you plan to have anyone present with you at the mediation, clear that ahead of time with your attorney. Come to the mediation with an open mind. Settlements take place at the mediation when both sides approach the process reasonably with an open mind and a willingness to compromise. There will be downtime during the mediation when I'm in the other room talking with the other parties or attorneys. Some people prefer to bring something along to read or do during that downtime, and you are welcome to do so. When you need a break or time to step out of the mediation to take a deep breath, we will accommodate you. We want you to be comfortable during your mediation. Typically, there is a limited selection of drinks that are available to you during the mediation. I also make sure that there are some snacks available. I don't want people to be hungry during the mediation because it's just not helpful to the process. If you wish to have a particular food or drink available to you at the mediation, please feel free to bring that with you. So, how did I become a mediator? I was a trial attorney for 30 years. I took many cases to trial over the years, and this trial experience has given me a deep understanding of the potential risks and the potential benefits of taking cases to trial. My experience as a trial lawyer gives me insights that I can offer to you or the other side that can help bring your case to a settlement. I choose to work as a mediator because I want to help people like you and your attorney to try to resolve cases before they go to trial. I enjoy working as a mediator, and I want to make sure that I'm doing everything possible to facilitate settlement of your case. Not every case settles during mediation. However, the majority of cases that I mediate do get settled at the mediation or shortly after the mediation. For those of you having your mediation at my office in the Waterford Complex in Eau Claire, please pay careful attention to the directions available on my website. It can be confusing when you enter the Waterford Complex. Consider printing the directions so that you have them with you when you come to my Eau Claire office. If your mediation is being held at another location, please make sure you have clear directions ahead of time to get you to that location. If you have questions about anything that I've said today, please direct those questions to your attorney or your attorney's assistant. I hope that you're feeling more comfortable about your upcoming mediation. I look forward to meeting you and working with you and your attorney toward resolution of your case.